May I please this honorable court to hear the honorable Okon. My Lord, I announce my appearance for the claimant.
Yes.
May it please your lordship, Assam Jr. My lord, I hold the brief of Nsikat Effiong, Esquire, for the defendant, my lord.
Holding the brief of
Nsikat Effiong, Esquire. Yes, sir. Yes, my lord. Nsikat Effiong. My lord, for the defendant.
Is ready. Hello. Hello.
Hello, my lord.
As the court pleases.
I want to confirm representation here. What I have is AA Osuko with Ofonobong Okon and Ekomobong Andrew for the claimant. Is that correct?
Very well, my lord, that's correct.
Good. Isika Effiong for the defendant. Is that correct?
Very well, your lordship. Very correct, my lord.
So I require your kind permission to go straight to my judgment so as not to experience these technical hitches we did before.
As the court pleases.
Do I have your permission?
Very well, my lord.
As the court pleases.
Okay. So this is my judgment. I have painstakingly gone through the originating summons, the affidavits, the written submissions, and had learned counsel for the parties, and it is my considered view that the issue needs to be resolved is whether the claimant has proved his case to be granted the relief sought in this case. In the consideration of this issue, the question raised by the claimant come to the fore. But before I do that, it is pertinent to consider some preliminary issues germane to this case. One of such is the introduction by way of preliminary objection in the defendant's amended final address of the issue, whether or not the failure of the claimant to exhaust internal avenue first and notify the first defendant of her intention to sue robs the court of the jurisdiction to entertain the claim. Although differently couched, this is the same subject matter of the preliminary objection filed on the 21st October 2022, in which a considered ruling dismissing same was delivered on the 20th July 2023, based on the same argument. The defendant cannot therefore smuggle this issue for consideration again. The issue having been decided and rested is hereby discontinued in this judgment. Also discontinued is the further argument of the claimant filed on the 30th November which is a response to the introduced preliminary objection. There is also the rejoinder on points of law filed on the 1st April 2023 by the claimant on questions 1, 2, 3, and 4 of the originating summons, which were argued together by the claimant but argued separate by the defendant. All the claimant did in the said rejoinder was to argue and sometimes seek to improve on the arguments offered in her written address. This is not the purpose or function of a rejoinder. A rejoinder on points of law is not supposed to be a repair kit to correct an error or lacuna in the initial address. No, is it meant to have a second bite at the cherry? See the case of Ogulo and Mobro, Masiko, Motorola and Woolman, Harka and Kezia, Philips and Eba Idol, Taliu and Wasiu, Isiaka and Amon and others, to mention but a few. Since the self-rejoinder by the claimant is in the instant case is a mere repetition of the argument in the written address and therefore a clear negation of the above principles, I have no option but to discountenance the reply in this way. I will now take the substantive issue, that is, whether the claimant has proved his case to be granted the relief sought in this case. And in so doing, I will only refer to the arguments of the parties where necessary. Are you with me?
Yes, my lord.
Okay. The suit is predicated on the interpretation to be accorded Section 5, 6, and 7 of the Akwa Ibom State Polytechnic Law on the Constitution and Composition of the First Dependent Government Council and its effect on the suspension of the claimant. The suit is an invitation for the court to interpret these sections of the law to determine if the setting up of the investigation committee is in accordance with the law and if the governing council of the first defendant can sit with less than 5 members to suspend the claimant. The burden is on the claimant to show that the existence of these assertions, and because she is the one seeking for judgment on the existence of that certain fact, the burden of proving those facts exist rests on her. In other words, he who asserts must prove. See the case of Buhari and Obasanjo, Bayelsa and Rivers, Owimiloju and Emibere, Ikewu and Nigeria. And these propositions are also the purport and tenure of sections 131, 132, and 3 of the Evidence Act. There is also the requirement that the claimant must do so on the strength of her case and not on the weakness of the defense, subject to some exceptions. See the Supreme Court case of AIC Limited and NMPC and Abimbola and Abata. It is therefore the duty of the claimant to not only prove that the committee was not constituted in accordance with the law establishing the first defendant, but that the subsequent suspension of the claimant was null and void, thereby entitling her to the relief sought. Whether or not the claimant will succeed in this quest will depend on the manifest intention of the section of the law upon a calm interpretation of the said section in the light of some statutory provision and case law authority. At the risk of repetition, it is imperative to reproduce pertinent section of the Akwa Ibom State Polytechnic Law relied upon by the claimant as follows. Section 5, and I quote, there is hereby established for the proper management of the affairs of the Polytechnic a governing council to be known as the Council of the Polytechnic. 2. The council shall consist of a chairman to be appointed by the governor, B, the rector, C, the head of technical education in the ministry. 3. The registrar of the Polytechnic shall be the secretary to the council. 4. The provision of schedule to this law shall have effect with respect to proceedings of the council and other matters therein mentioned. End of course. Section 6 of Section 2. I quote, the council may appoint committees consisting of only its members and may delegate to them such of its powers as it deems fit, but no decision of any such committee shall have effect until confirmed by the council. Section 6 of Section 5, I quote, notwithstanding the delegation under Section 2 and subsection 4 of this section, the council may itself perform any or all of these functions. End of quote. The interpretation of this section is the subject of immense debate between the parties. To the claimant, the fact that the word may is used twice in subsection 2 of the law must be interpreted to mean shall, particularly when in law may can sometimes be interpreted as shall in some given situation. And since the object is to give effect to a legal right in this case, on the authority of Sheriff and another version, PDP, may must be construed as compulsory and as imposing an obligatory duty specifically when the setting up of the committee made up of members drawn from outside council members was a clear breach of the provision of Part 2, Section 6 of the law, thereby rendering the second defendant with no legal standing or power when it sat and suspended the claimant, and also invited her to the investigation committee of the council, presided over by the second defendant without the necessary quorum for the meeting. To prove this assertion, the claimant attached 3 exhibits, to which report by the Committee on the Review of the Issuance of Statement of Results and Certificates to postgraduates of the defunct distant learning centers of the first defendant from 2009 to 2013, that is Exhibit 1. Letter of suspension, Exhibit 2, and letter listing director of the first defendant to appear and testify before the committee of the second defendant, Exhibit 3. Whether or not these are capable of proving the assertion before the investigation committee. It is the further argument of the defendant that having participated in the proceeding, the claimant cannot turn around and accuse the council of improper composition, notwithstanding the attempt by the claimant to disqualify the rector of the first defendant by the invitation to cross-examine him as a witness in order to deplete the number of members of the council. The defendant also denied the receipt of Exhibit 2 as the claimant failed to produce any acknowledgement to that effect. The defendant also accused the claimant of failure to place the facts for the court to interpret the section of the law and apply it in the circumstance of this case, while stating that the attack on the composition of the committee is a direct affront to the statutory powers of the council to delegate powers as it deems fit, noting that delegation of power is not in law suppression of power. On the interpretation of may in section 62, the defendant contended that the provision of statute must be read together and not disjointedly for ascertain the intention of the framers. Under section 6, subsection 2, read together with subsection 5, gives the governing council of the first defendant power to constitute any committee that comprises both the council and non-council members, if it's in its opinion, such elastic mix shall achieve the function of the polytechnic and serve its best interest. It is therefore the contention of the defendant that the word may in all the subsection of section 6 of the polytechnic law is used in the permissive sense and not mandatory, and that the choice of the number of committees to be constituted is not limited or defined, but rather is left to the council to decide on behalf of the institution. Hence the use of the word committees after the word may. To the defendant, the choice of any such committee is for the purpose of delegation of powers and the council deems fit, and if the intention of the law was to restrict membership of the committees only to the council members, the need to delegate to them such powers will not arise. The defendant also submitted that by Section 6 of the Polytechnic Law, the council has the power to constitute committees from the members of the council, which may also include non-council members. The only requirement is that the decision being advisory is ineffective and not binding until confirmed by the council. It is also the contention of the defendant that Section 6 of Section 1 has given the council limitless power to manage the affairs of the polytechnic and to do things which in its opinion shall achieve the function of the polytechnic and serve its best interest, subject only to the commissioner. On the suspension of the claimant without pay, the defendant contended that the claimant on lies the proof of the illegality of the suspension has failed to provide the condition of service which is the bedrock of which an aggrieved employee must find his case. And by virtue of Section 13 of Section 5 and 6 of the Polytechnic Law, the suspension without pay of staff is within the competence of the council and is at the discretion of the council to be exercised without the aid of anybody or person. Not only that, the law is settled that an employer has the right to discipline any erring employee in the interest of the organization or institution, and that since the claimant was suspended without pay in compliance with Section 13 of Section 6, the defendant had every reason to suspend the claimant. To justify this, the defendant annexed about 35 exhibits, most of which are documents evidencing the events leading to the suspension of the claimant. The question now is, given the state of pleadings and submission of parties, can it be said that the claimant has proved the lack of quorum of the council of the first defendant, the improper constitution and composition of the committee, the impropriety of the eventual suspension of the claimant? The answer to this is in the negative for reasons that are manifest. To start with, the lack of quorum of the council of the first defendant in sitting and conducting proceedings at the governing council leading to the constitution of the investigation committee is not proof, apart from citing Section 3 and 5 of Polytechnic Law to state that the quorum for a meeting of the council shall be 5, and that any meeting of the council held with less than 5 members shall be a nullity. No effort is made by the claimant to show that at the time the council sat, it has not formed a quorum. The claimant only referred to the proceedings without the minutes of the meeting to show the attendance and lack of quorum. So, without this, the allegation that the governing council of the first defendant comprising of the second defendant had no powers when it started and suspended the claimant and also invited her to the investigation committee presided over by the second defendant without the necessary quorum remain speculative. There is therefore sense in the submission of the defendant that while calling for a meeting of the council of the first defendant is 5 statutorily, the claimant has failed to place the fact of the case for the court to interpret and apply the law to justify the interpretation in that regard. The Supreme Court cases of Lekot and 10 others versus Judicial Tribunal on civil and communal disturbance in Kaduna and another, and Oye Kudeloje, let me take it again, Onye Kuloje and BSG, to the effect that no court can set aside or nullify or quash any proceedings or decision not before it is apposite here. Closely connected with this is the interpretation of Section 6, subsection 2 of the law to infer that setting up a committee made up of members drawn from outside the council members was a clear breach of the law to render Exhibit 1 liable to be set aside as a nullity. In the interpretation of that, the court must reckon with some basic principles. It must endeavor to give what used in the statute is ordinary, natural, grammatical construction, unless such interpretation will lead to absurdity or inconsistency with the rest of the legislation. See Alaji Adisa and Onyuola, Rav Ourele and AGF, Ameti and INEC, Gasol and Turari, Abbasani and President of the Federal Republic of Nigeria, to mention but a few. That the court should, as much as possible, make broad interpretation for what is sometimes referred to giving interpret a liberal the interpret. Sorry, let me take that again. That the court should, as much as possible, make broad interpretation of what is sometimes referred to as giving the interpretation a liberal approach. See the case of Rabiu and said that the court should give holistic and purposeful interpretation to statutes as required by law. See Mobile and IAL Incorporated and NUR. Is somebody hello? Are you people with me? Is it okay?
Yes, my lord.
Are you hearing me?
Yes, my lord, we are hearing you.
I can hear some noise.
Yes, I don't know where it's coming from.
Okay, maybe it's in chambers of one of them.
Yes.
Okay. Please, can you mute your system? Can you mute your system, please?
Back in history, please mute your system. You are obstructing the National Industrial Code proceedings. Back in history, please mute your system. You are obstructing the National Industrial Code proceedings, please. Sorry, my lord.
Hello? 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 Are you hearing me?
My lord, we are hearing you. I'm trying to get to this other lawyer.
I can't even get him from my system too.
Back in history, please mute your system. You are obstructing the National Industrial Code proceedings. Mute your system, please.
Beautiful.
Back in history, please mute your system. Mute your system.
He can't hear you.
Can't hear me. Hello, back in history. Please mute your system. Mute your system.
That's why
Mrs. Okon. Mrs. Okon, do you have his number?
Yes, we are trying to connect to him.
Please reach out to him. Let him mute his system.
Yes. All right, my lord.
Okay. Why did I stop? Okay. Flowing from the above principles, the provision of section 6 of section 2, which is clear and unambiguous, must not only be interpreted holistically, but according to its ordinary, natural, and grammatical construction. It is in this wise that the use of the word may in section 6, subsection 2 is to be given its natural and ordinary meaning, which connotes permissiveness and not mandatoriness. See Main Street Bank and Nigeria Insurance. So a liberal and purposeful interpretation of section 6 will leave one with no other conclusion but that the appointment of persons who are not members of the governing council of the first defendant into the committee was in conformity with the law. Any other interpretation sought by the claimant would have led to absurdity, and it would be almost impractical for a council consisting of only 3 members, chairman to be appointed by the governor, rector, and the head of technical education in the ministry, to appoint committees only of its own members. Not only that, the contention of the claimant that may, as used in section 6, subsection 2 of the Polytechnic law, has to be interpreted to mean shall. In this case, is a resort to construction by implication, which is frowned at in law and permissible only where the meaning of the statute is not clear. This is the case of Adisa and Oyuola. In any case, the claimant has failed to bring the fact of this case within the application of the word may used in section 6 to connote shall. See the cases of contract resource versus UVA, Okonkwo and UVA, PDP and Modu Sharif. On the contention by the claimant that the committee that produced the report consisted of non-council members and as such is a nullity, who should be set aside, I'm in agreement with the defendant that the claimant who appeared before the committee knew of its composition but chose to submit to the panel cannot complain about the composition of the panel on the authority of the Jibrin and the military administrator of Kano State. Again, for the claimant to succeed in setting aside the suspension and restoration to the position of the registrar of the first defendant, he must first of all prove that the suspension was unnecessary, unreasonable, invalid, and hence unlawful. This the claimant failed to do woefully. See Bishiriu Adekoke and Lagos NURTW Cooperative Society. The law is also settled that it is within the disciplinary powers of an employer to suspend an employee for purposes of investigating an infraction or as punishment for an infraction. If Bernard Long gave an First Bank, Mrs. Abdurrahman Yetunde Mariam and University of Ilori. So it is not only within the discretionary rights and powers of the defendant to suspend the claimant on the allegation of misconduct on the issuance of statement of results and certificate for the defunct distant learning center for the first defendant, but the defendant reserves the powers under section 13, subsection 6 of the Polytechnic to suspend the claimant without pay. By way of conclusion, it should be noted that the claim for perpetual injunction naturally depend on the success or otherwise of the declaratory relief claim and is a consequential order which should naturally flow from declaratory orders sought and granted by the court. T, Obi, and Obiowa, Afrotech and Mia, Obi and INEC, Olorum, Tobojo, Ojo, and Dopamo. It is also a fundamental principle of law that a court will only grant perpetual injunction a dispute of a claimant in support of the right known to law and equity to prevent permanently the infringement of those rights and to obviate the necessity of bringing multiplicity of suit in respect of every repeated infringement. This is not the case here. On the whole, the case of the claimant is hereby dismissed for lack of merit and proof, with no order to court. This judgment entered accordingly. Hello?
I know you are grateful for that judgment.
Are you sure?
Yes, I did.
Okay. Call the next case.
My Lord, we are very grateful for the well delivered judgments. We thank my Lord.
I know you said that because it's in our favor.
As the coffee. Thank you, my Lord.
Next.
Thank you, my Lord.
Thank you.
My Lord, I seek your permission to question number 4. All the papers have been filed for adoption. Lord, number 4 is for adoption. All the papers have been filed.
Number 4.
Yes, my Lord.
I can't see you again. I can only hear you, but that is okay.
All right, my Lord.
Number 4 is 47.
Yes, my Lord, it's 47.
Call the case.
Suit number NICN UY 47 2020 between Chijioke Francis Anizo and Fidelity Bank PLC. My Lord, parties are absent in court.
Yes.
My Lord, with respect, Philip appear for the claimant.
Yes.
My Lord, with respect, my name is Francis Ekwere. I appear for the defendant.
Francis
Ekwere, my Lord. Francis Ekwere for the defendant.
Yes.
But the defendant's final written address was filed on the 27th. My lord, the defendant's final written address
Was filed
27th day of December 2023. 27th day of December 2023.
Yes.
Lord, we adopt the same as the final arguments in this case and urge my lord to dismiss the suit.
Yes.
My lord, on the receipt of the claimant's final written address, we filed the defendant's rejoinder on the 8th day of February 2024. The defendant's rejoinder was filed on the 8th day of February 2024.
You filed when?
Lord, 8th February 2024. February 8th, 2024.
Yes.
Lord, we adopt the same and urge my lord to dismiss the suit.
Yes.
My lord, respectfully, the claimant filed his final written address on the 1st day of February 2024.
On
The 1st day of February 2024.
April 2024.
February, my lord. February.
You said April. Yes.
My lord, the 1st day of February 2024.
Yes.
We adopt same as our argument on behalf of the claimant, urging this court most respectfully to grant all the relief sought by the claimant in this case. We so urge, my lord.
Is it Okon?
Yes, my lord.
Can you give me a date in today is 15th.
15th of February, yes, my lord.
Can we take 15th of March?
15th of March.
Yes.
Yes, my lord. My lord is on a Friday.
Okay. So let's take the Monday is
Monday is 7 p.m.
are you sure?
18, my lord.
No. Case is hereby adjourned to 18 March 2024 for judgment. Thank you. Next.
18 March.
Hmm? Next.
All right.
Number 20.
Number 2.
Eh?
Number 2,
2.
my Lord. Yes. Suit number NICN UY 27 2020 between Mr. Effiong Sunday Akpanimo and Federal Inland Revenue Service. A lot of the parties are absent in court.
Representation. Appearance.
None, my Lord.
This is Okon.
Yes, my
Have
Lord.
they filed their final appeal addresses?
My Lord, the defendant has filed his own since last year. So we are waiting for the claimant to file. Claimant is yet to file.
When are we adjourning the two? Hmm?
Oh, let's adjourn it to 15
March.
15 March.
Yes.
All right, my Lord.
To 18th.
Okay, 18th. All right, my Lord.
This is 27, right?
Yes, my Lord.
Next.
My Lord, number 3. Suit
35.
number, yes, my Lord. Suit number NICN UY 35 2020 between Joseph Robert Bassey.
Yes, my Lord.
And Akwa Ibom State University. The registrar, Akwa Ibom State University. My Lord, the claimant is present in court. Defendants are absent.
Appearance.
Maybe it's my Lord to hear. Peace, William.
Please.
William, my Lord. Peace, William. My Lord,
Yes.
I'm holding the I'm holding a brief of Samuel before Esquire.
Samuel.
Samuel before. My Lord, Samuel before Esquire for the claimants.
Yes. Yes. Any representation for defendant? Hello?
Yes, my Lord.
Who is for the defender?
Let's leave the court to hear Eduwem Etem.
Eh?
Eduwem Etem. Eduwem Etem. My humble appearance is for defendant.
Yes.
My Lord, respectfully.
Who is speaking?
My Lord, the counsel for the claimants.
Okay.
My Lord.
Yes.
My Lord, on the 10th day of July 2023.
You said?
My Lord, 10th day of July 2023. This court had ordered the defendant or the parties to file their final written addresses, my Lord, starting from the defendant. My Lord, up to date, the defendant has not filed or have not filed their final written addresses to enable the claimant file his own. He will not speak.
Yes.
My Lord, this is about 8 months. My Lord, they have not done it. The defendants have not done anything. So my Lord, on that note, we want to humbly pray this court to award cost of 200,000 naira against the defendants. My Lord, maybe that will cause them to sit up and be serious.
Are you broke?
My Lord.
Are you broke?
He said, are you broke?
Yes, my Lord.
It's sign of the times, right?
Yes.
I was thinking you will apply to foreclose them. Go ahead with your case, not to ask for cost. You can't hear me.
We don't want to ask for foreclosure. I know we're asking for cost. What to give them another thing? Maybe, my Lord, when the cost is awarded, they could do something.
Let me hear it.
Yes, my Lord.
My Lord, we are so sorry. We intend to file our final written address very soon. My Lord, will be asking for, we are just pleading for a very short time. We are in the process of filing. We are done with the address and we intend filing very soon, my Lord. We are praying the courts for a very short time, for the very last time, my Lord. We will definitely file.
But you are not saying anything about the cost.
My Lord, in the interest of justice, my Lord will file soon. My Lord, as regarding costs, I seek the leave of court to
take over from my learned friend, Edowem. With due respect, my lord.
And under what procedure is that?
My lord, I'm very sorry. I come under the inherent jurisdiction of the court for me to take over and lead.
That is a smart one. Go ahead.
Thank you, my lord. My lord, may I first of all apologize for causing noise in this court today. It wasn't deliberate. I am in another court in Ikorobasi, so I had to just monitor proceedings to know when to step out. And my speaker was on. I didn't know. I struggled to mute it, but I wasn't able. My lord, throughout my years in secondary school, there was no computer at that time. And I'm struggling to adapt now, my lord. I'm so sorry. My lord, to today's matter, my lord,
Yes,
okay, as a couple places.
Yes.
My lord, as my learned friend Duwem has noted, I am yet to complete the final written address. My lord, I am 95% ready with the address. I say this from the bar, my lord. I am 95% ready for the address. I spoke with my learned friend, the Clement, in person yesterday. And I had issues about the numbering of the exhibits. My lord, he tendered about 50 exhibits, and they were admitted by the court and marked exhibit CW1 to 50 something. And I had issues with the particular ones that were marked as 10, 11, 12, and so. So I spoke with him, and he promised that he will make it available to me today. And earlier today, he sent some to me. And my lord, I am making a promise from the bar that as soon as I'm out of this court, I will complete what is remaining and then have it filed not later than Monday. I will file and get him served. Even before filing, I will serve him the soft copy. I am just praying the court. I know it has taken a bit of time, but I'm apologizing and praying to the court for the shortest possible adjournment. I will ensure that what I'm doing is filed. And even before it is filed, I promise to send a soft copy to my learned friend so that he can even begin his response to it, my lord. I'm asking with due respect for a date, the shortest possible date. I am okay with it, my lord.
You are not saying anything about the cost.
Well, my lord, I did not join at the time that cost was mentioned. I don't know how much my learned friend has mentioned.
He asked for 200,000 cost.
Well, my lord, he's not asking for too much, but my lord, I pray the court to tender this with mercy on counsel. My lord, I will give 20,000 naira from my own personal account to Learned Counsel to assuage for the delay. I know that my learned friend would have prepared his own address.
Will 20,000 bring her to court?
Well, my lord, I am begging, I am soliciting that I be made to pay 20,000. My lord, I'm paying it from my own pocket. I'm not applying to my clients for that.
Why
I know
not?
that cost follows events. The matter was slated for adoption today. Having not been adopted, my lord, I know that cost should be paid. I pray that I be made to pay 20,000 naira as a community.
Why are you shielding your client?
Well, my lord, believing that my client is not in this court today to hear me, my lord, between counsel and the court.
Or are you taking responsibility for failure to file?
My lord, the failure is that of counsel. That of counsel. My client had paid me for this matter 2 years ago, and my lord, let counsel be the one to bear this cost because it is that of counsel, not that of my client, my lord.
Then
My lord, I know that 20.
I'm 1650K.
Well, my lord, I see crave the indulgence of the court for me to pay 20.
Okay, let me hear.
My lord, respectfully, the 50,000 naira, my lord, will be paid to both counsel.
No, she said, because I said 50.
Oh, my lord, that was what he had in mind. My lady friend has already.
Are you a mind reader?
Are you a mind reader? Are you a mind reader? Are you a mind
You
reader?
said that is what he had in mind.
No, my lord, I was not reading my lord's mind. My lord, that was what I had in my own mind.
Do you agree with the 20,000?
My lord, 50,000. That's my lord.
My lord, if I may still say something by way of rejoinder on point of the money, my lord.
Yes.
My lord, the economy is very, very tough on everybody, including counsel. My lord, if I am asked by the court to pay 20,000 naira, my lord, I know that my pocket can easily pay that. I can even pay it today or tomorrow. I still pray the court for the indulgence of the court for me as counsel to pay 20,000 naira to my learned friend. My lord, I think if I do that, it will go a long way to assuage them by buying at least 2 or 3, 4 reams of paper to assist them in running their own
I was
written
thinking you are
address.
going to talk of fuel, not paper.
Well, my lord, even that, even if for fuel, my lord, it will still buy some quantity of fuel for them to drive to court on the next adjourned date, my lord. I leave this to the court, but my lord, I will be grateful if this court is magnanimous enough to
I will be
grant me the
magnanimous,
permission.
but not enough.
As a complice.
The cost of 30,000 is to be paid to the claimant counsel before any further step is taken on this matter.
As the court pleases.
As the court pleases.
Magnanimous, but not enough. Yes.
Hello, maybe
Any
don't wait,
date? Any date? Any date in mind?
Yes, my lord, any date available to the court is convenient for me, my lord.
Hello, the 18th day of March is a Monday, my lord. It is convenient.
Sorry?
18th March is a Monday. It is convenient to the court.
That's in.
1/8.
1/3 or 1/8?
1/8. 18, 1/8.
Okay. It's convenient, my lord.
Case is hereby adjourned to 18 March 2024 for adoption.
As the court pleases.
Hello, we are grateful.
The court pleases, my
Most
lord. My lord, I am
most
most grateful to this honorable court.
You're welcome.
Most respectfully, my lord, may I indicate my interest number NICN UY/03 2019. Thank you, my lord.
Lord, I am most grateful.
Elon may also respectfully observe that the camera of your device is turned upwards.
How?
It's turned upwards. We're seeing the ceiling of your chambers. Yes, my lord.
Sorry about that. Is it
It's all
okay
right, my
now?
lord. It's okay.
No,
It's okay. It's a little much up there. It's better now, my lord. We're grateful. Thank you, my lord.
Yes.
Suit number NICN UY03 2019 between Mrs. Arit Okonokwon and the government of Akwa Ibom State, Agnes Uwo Okwon, alias Mrs. Arit Okonokwon. My lord, the parties are absent in court.
Appearance.
If it pleases me, Lord, I appear for the claimant in this case. My name is A.M. Aziz.
Yes.
No, my learned friend Sharon Edie usually appears for the first defendant, while Kingsley Akaiso Esquire usually appears for the second defendant. It appears they are not online. They are not in court.
Yes.
My Lord, the defendants closed their case for the second defendant, particularly on the 23rd day of October 2023, and thereafter they were given their statutory 21 days to file their final written addresses. But up till now, my Lord, the defendants have not filed their final written addresses.
You said they closed their case
On the 23rd day of October 2023.
Yes.
Lord, thereafter, the matter was adjourned for final written addresses. Lord, their period has since expired. Until date, there's no written address filed by either of the defendants or any motion for extension of time to so do.
Yes.
My Lord, the defendants having not shown any cogent or compelling reason for not filing their written addresses, respectfully apply that they be foreclosed by the provisions of Order 45 Rule 12 of the Rules of this Honorable Court.
You cannot do that orally.
Very well. Lord is talking about final written addresses.
Yes. All applications have to be by way of motion or not.
Very well, my Lord. My Lord, may we also apply in view of their absence from court and no excuse given.
Yes.
Having been aware of the notice of this virtual hearing, a cost be awarded in favor of the claimant. So we're asking for 50,000 naira each against the two defendants.
Application for court is hereby refused.
Very well, my Lord.
Give me a date. That is the only thing I can do for you.
Very well. As the court places. Let me suggest the 18th day of March.
Case is hereby adjourned to 18th March 2024 for adoption. Defendants serve hearing notice.
As the court wishes.
I'm much obliged, Lord.
Yes.
Suit number NICN UY02 2022 between Elder Dr. Joseph O. Eliezer and Utai Lee Nigeria Limited. Lee Pindin. My lord, parties are absent in court.
Yes.
May it please your lordship, Assam Jr. My lord, I appear for the claimant.
Yes. Yes.
My lord, my learned friend, R.O. Onyeson used to appear for the defendant. However, I do not know. I'm sure he was notified of this proceedings, but I do not know why he's not in court. However, your lordship, the defendant is yet to file his final written address, and we are also yet to file ours. So, in the circumstance, we'll be praying your lordship for costs to be awarded against the defendants for failure to file their final address within the time specified, your lordship.
Application for court is hereby refused and case adjourned to 18th March 2024 for adoption. Defendants will be put on notice.
The court, please.
The court pleases. Thank you, my lord.
You're welcome. You want to test if I'm going to be consistent, right?
Yes, my lord.
That is to tell you I'm a human being. I'm inconsistent.
Thank you very
Yes.
much, my lord.
Yeah. Mrs. Okon,
Yes, my lord.
I have 49 2020
Yes, my
for
lord.
adoption, but you have not put it.
Yes, my lord. Their own date
Uh,
was slated for in 2 weeks' time to come, my lord. That was why
Okay,
when,
but
uh,
did they file anything?
my lord, they are filing today.
No.
Yes, my lord.
So you need to remind me about that date.
Yes, my lord.
Thanks.
Thank you, my lord.
In the absence of any other business, the court shall close.
Court.